Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back on a topic that we've really spent a lot of time talking about. It's one that we feel very passionately about here at Washington Gun Law, which is the disarmament of individuals who commit felonies and then the inability for many of them to actually restore their rights. And we're really having this kind of post-Bruin enlightenment, this awakening when we're taking a look at this entire legislative scheme when it comes to disarmament. After all, we've already had Rahimi argued in front of the United States Supreme Court. We got the Daniels case, which deals with cannabis users. We got the Range case, which deals with nonviolent felonies, sitting on the doorstep of the United States Supreme Court. And while I understand there is a tradition sometimes of disarming people, what I really am struggling with is the inability of these people to ever restore their rights in some jurisdictions. Could you imagine a state where no matter what you did, no matter how long ago, no matter how innocuous it was, no matter how much you've changed, you could never, ever restore your Second Amendment rights? What state would ever do that? That's right. It's California. And guess what? That law just got struck down, and it wasn't by Judge Benitez, and it wasn't even by that court. But once again, California has taken one on the chin. So today, let's geek out on the opinion. Let's talk about California gun control gets flattened again. You know, I bet you wish you could go and do this every day, but you don't, do you? And I imagine you wish your groups looked a lot like this, but they don't, do they? No, instead, they have a tendency to look a little bit more like this. Plus, you might have noticed that this stuff ain't very cheap anymore. Or, just hear me out, you can use your Mantis X10 Elite training system like I do. Listen, this thing is way too easy to use. Step 1, install the Mantis training app to your smartphone. Step 2, install the Mantis X10 Elite training system to your firearm. It's as simple as this. Step 3, open up the training app, select your program, and away you go. Listen, you can practice in the comfort of your own home. This app will store all the data. It will tell you what you're doing wrong, what you're doing right. It will tell you what you're improving on and what you need to work on. The best part is, all you need is your firearm and the Mantis X10. You don't need any ammunition, and you don't need any expensive membership to a range or a gun club. And right now, if you want to check this revolutionary system out, all you got to do is click on that link right up there. For more information, visit our good friends at mantisx.com. Okay, what are we talking about today? We are talking about the case of Hinton v. Bonta. It is a case brought to us by our good friends at the Second Amendment Foundation, who have finally today secured a summary judgment in a case that was filed in December of 2018. What's at stake here was 3 named plaintiffs. There was a lot of plaintiffs involved, 3 individuals, and I want you to understand what these individuals were, and I want you to understand what was at stake. What's at stake here is California Penal Code 29800, which, interestingly, reads as follows. Any person who has been convicted of a felony under the laws of the United States, the state of California, or any other state, government, or country is prohibited from owning or possessing firearms. Now, if you notice there, it's just like, hey, if you've ever received a felony conviction, TS, you don't get a firearm in the state of California. Did they really mean that? After all, the court pointed out the federal counterpart, 18 United States Code Section 921, says the following. Any conviction which has been expunged or set aside, for which a person has been pardoned or has had civil rights restored, shall not be considered a conviction for purposes of this chapter unless such pardon, expungement, or restoration of civil rights expressly provides that the person may not ship, transport, possess, or receive firearms. So the big rub here is that even though the federal counterpart and just about every state in the country will allow some ability to restore so long as the conviction is of a certain nature, the state of California, nope, a blanket prohibition. Now, what's the problem? Well, the problem for these 3 plaintiffs are as follows. Plaintiff Hinton was a member of the United States Navy back in 1987, got busted for eluding a police vehicle on a brief pursuit in the state of Washington, was discharged from the Navy, had all of his rights restored in Washington State, had gone through all the restoration process, tried to purchase a firearm in California. California said, nope, not gonna happen. Plaintiff Stewart was convicted in 1976 in Houston, Texas for stealing some tools off a job site, got all of his rights completely restored, the conviction expunged, vacated, whatever he needed to do down there, California still never allowed him to buy a firearm. The third one is probably the craziest. That's plaintiff Jones. He was a Department of Corrections officer from 1984 to 2013 and actually was given permission by the state of California to own a firearm until they suddenly matched up some databases in 2018. From that point forward, he could no longer possess a firearm lawfully. Now, of course, the state of California came up with some of the usual challenges that you see. The first one, of course, being standing. Hey, nobody has standing to even make this challenge. Of course, this did deal with these individuals' right to possess firearms, so the court was not too persuaded by that. And they also argued that they had an 11th Amendment privileged immunity, which obviously went nowhere because we are talking about the results of this ruling. So that means we're going to have to get into the Second Amendment claim. That means we're going to have to get into a Bruin analysis, and that means California is going to get themselves in a lot of trouble here. As the court outlined the issue, plaintiffs were convicted of nonviolent felonies decades ago when they were in their earliest of adulthood. Each conviction was set aside or dismissed by the jurisdiction in which the offense occurred, and the record indicates that all three plaintiffs have been law-abiding citizens in every respect other than the youthful misconduct. Even so, California has acted to permanently deny plaintiffs the right to possess or own firearms solely on the basis of the original convictions. Now, interestingly enough, this is an as-applied constitutional challenge, not a facial challenge, which means we're not challenging the overall constitutional integrity of the statute. Instead, we're challenging the constitutionality of the application of this statute to these particular individuals, as the court put it. Plaintiffs bring an as-applied constitutional challenge to California Penal Code sections 29800 and to California's policy of refusing to honor the set-aside invocation of felony convictions and restoration of firearm rights by the courts of other states. A successful facial challenge will invalidate the law itself, while a successful as-applied challenge invalidates only the particular application of the law. So, much like what we talk about with concealed carry reciprocity, the state of California, marching to their own drummer, clearly knows what's best for everybody, and they're doing something completely different than the other 49 states. And therein lies the rub and the problem that the court has when we apply it to these three individuals. Now, let's also point out that all three of these individuals fall in exactly the same category as range, and the range case is actually mentioned in this opinion. Okay, so now that we have to get into Second Amendment arguments, the state of California has to come up with something, right? And what is it? Well, it's that these plaintiffs don't qualify under the people as announced in the Second Amendment because, you see, they're not law-abiding citizens. They got these old felony convictions. And the people is only the law-abiding responsible people. And they also argued that it was actually the plaintiff's job to prove that they are a member of the people. The court was not persuaded. They said, actually, no, you need to disprove it. Or as they put it, California ignores this strong presumption to suggest that the party challenging a restriction under the Second Amendment must first demonstrate that they are within the Second Amendment's protection. Not so. Plaintiffs are plainly among all Americans who are presumptively granted rights under the Second Amendment. The government cannot posit that a citizen is excluded from the Bill of Rights until he or she proves otherwise. It is the government's burden to demonstrate that the presumption of a constitutional right may be overcome. And then, of course, they said, hey, well, listen, California, if you got some case law that demonstrates that these people are not considered part of the people, why don't you show us? Or as they put it here, the other serious flaw in California's argument is the absence of case law supporting its position. California did not identify any authority for the proposition that the plaintiff's prior convictions categorically and permanently disqualify them from Second Amendment rights, irrespective of the subsequent judicial orders that vacated or set aside those convictions. And then, of course, the problem for California, as is often the case, is that there is no historical analog to support this type of disarmament legislation. There is no historical precedent that says we as a society have accepted this level of disarmament. And the case that California relied upon, unfortunately, was a case that involved an individual who was unlawfully possessing a firearm, and none of the convictions had previously been vacated before he asked to have his rights restored. So it was very much apples to oranges, and the court was not persuaded at all. The fact that other courts have rejected the categorical exclusion that California urges here underscores the weakness of its position. Most recently, the Third Circuit published Range versus Attorney General of the United States, which applied Bruin in a Second Amendment action conceptually similar to this case. And so you begin to see some encouraging signs here, which is this analysis that was developed in the Range case and could theoretically be even further developed by the United States Supreme Court, is going to be the way that a lot of these nonviolent felons who have ages-old convictions out there will find grounds for restoration once again. Now, how did California do at least coming up with some type of historical analog? California did not come close to meeting its burden. It did little more than recycle old case law to say that history shows the right to bear arms was inextricably tied to the concept of a virtuous citizenry, and that accordingly the government could disarm unvirtuous citizens. California otherwise presented nothing in the way of historical evidence in support of the conduct challenge here. It did not identify even one representative analog that could be said to come close to speaking to firearms regulations for individuals in circumstances akin to plaintiffs. California said, well, wait a second. If you really wanted all that historical precedent, all those historical analogs, why didn't you just ask us? The court was not too thrilled with that. It also bears emphasis that the court is not a helicopter parent. It is manifestly not the court's job to poke and prod litigants to live up to their burden of proof. And so ultimately, this is where the court has come down. Overall, California did not demonstrate that permanently denying firearms to these plaintiffs accords with the unqualified command in the Second Amendment of the right to bear arms. Summary judgment is granted in favor of plaintiffs on Second Amendment claim. The court need not take up other claims which are terminated without prejudice. Let us remember, a summary judgment is where a court has said, listen, I've reviewed all the facts, I've reviewed all the law, I don't believe there's any dispute, and guess what? You guys win, we don't need a trial. So this law, as applied to these three plaintiffs, is hereby dismissed. Okay, the California Penal Code, again, one more time, is 29800. The case, once again, is Hinton v. Bonta. We will link it all up down below so you can geek out on it for yourself. Fantastic work, Second Amendment Foundation. So we'll put a link down there. If you guys want to show them some love, you should do so. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. And then let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.